Good morning, Mr. Hill. Again, thank you so much for choosing me to come for advice on the situation. I've gotten all the details I've sent. I know this is worrying a time for you, especially after your surgery. You've lived there since basically birth from 1956, and the thought of having to leave is obviously distressing. So, I've gone through all the facts, and you promise in 1985, the 80,000 pounds you spent on the roof on the 90s, and you built the extension that you built in 2005, and the fact you've been continuously there for 70 years. And I've also looked into details on your little friend Miss Gray's situation in the East Wing. I'll be honest, there's some good and difficult news. I'll keep this as clear as I can. First, let's look at the good news. So on the facts alone, you actually do have a very strong claim. This is because of what we lawyers like to call proprietary estoppel. So let me just explain to you the meaning in the current context that we're having. So, your father made a clear assurance in 1985 in which he stated that this will always be your home and you never need to worry about leaving. You rely on that promise as you did not even move out. You even spent 80,000 pounds of your own savings on the roof and beam. And in 2005, you built an extension. And to top it all up, you also maintained the property's garden for 30 years. So now in law, when someone makes a promise and you rely on it and you suffer financial detriment because of that reliance, it will be quote unconscionable or unfair for the other side to go back on it. This is seen back in the case of Donald and Major, where a farmer worked unpaid for 30 years on an informal promise in which the House of Lords protected him. Another case, Gillett and Holt, says that the court looks at the whole relationship, in which yours, my friend, is 70 years long. Now, a legal commentator, John Mee, wrote an article about Toner. He explains that the courts are especially willing to recognize proprietary estoppel in family settings, where someone has acted on their detriment relying on insurance about their home or inheritance. That fits you perfectly. John Mee also points out that even oblique indirect assurance such like your father's comment can be enough, especially when parties are taciturn and the relationship is close. Additionally, academic writer Warcone's article on guests and guests supports the point on reliance as well. It explains that the starting assumption is that the promise will be enforced, although the court still check proportionality and unconscionability. So on the facts, you do have a genuine equitable interest in the West Wing, and arguably even the wider property. Now, here's where we have to come to the difficult part. Even though your claim is strong, there is still a legal mechanism called overreaching, and I fear that I might have detached your interest from the land itself. So when your father died in 2002, he left Upton Abbey to your sisters, Charlotte and Caroline. As equal owners, they were trustees. When they sold the property to Regent Estates Limited in 2025, the purchase money was paid to both of them jointly. Now, under the Law of Property Act 1925, where purchase money is paid to two or more trustees, any equitable interest like yours gets overreach. That means it lives off the land and attaches itself to the sales proceeds. In simple terms, your right to stay might have been turned into a right to the share of the money. So now in the case of City of London Building Society and Flag, a couple contributed to buying a house but the title was only in the parents' name. The parents mortgaged the house without telling them. The court said that the couple's interest was overreached because the mortgage money was paid to two trustees. Lord Templeman aided overreaching detaches the beneficial interest from the land. A helpful article by Nicola Jackson on overreaching in registered land argues that the Land Registration Act of 2005, 1925, actually has its own overreaching provisions, and that the House of Lords in Boleyn and Flag applied to the wrong statutes. In her view, even a single trustee should be enough to overreach, but the courts didn't take that path. Instead, they stated that two trustees are enough. Another commentator, Farros, has written about how the registered land system prides marketability and certainty, but has to manage the risk of fraud through overreaching. He argues that we need a principal narrative for registration, not just efficiency. His point is that overreaching is the price we pay for a clean market, but it can leave people like you in like a difficult spot. So this is the big hurdle. So if overreaching does apply, in which it will most likely will, as you have two sisters who are trustees, then your interest may no longer be in the land, and you might not be even able to be insist on staying on Upton Abbey anymore. Now you might be thinking, but I was living there and I was in the hospital for only like 2 weeks. My furniture, my clothes were still in the West Wing, and the developers it didn't even come to into my area where it was locked. In which you do bring up a very fair point. Under the Land Registration Act of 2002, a person in actual occupation has an overriding interest that can bind the purchasers. Temporary absence doesn't actually destroy actual occupation. In the case of Chokar and Chokar, a wife was in hospital giving birth, but the court said that she was still in actual occupation. And in the case of Ling Landing and Buster, someone detained in the psychiatric unit was still in actual occupation. Your 2 week stay is nothing compared to those cases. Additionally, the doubles didn't even enter your locked West Wing. This helps you as it shows that they did not even make reasonable inquiries. In the case of Kingsnor Finance and Tizard, a finance company was held to have constructive notice because their inspection was deliberately timed to avoid being seen by the occupier. Now, a writer named Chris Bevan has written a brilliant and detailed article on actual occupation. He dug into the historical archives and found that the provision was originally introduced in 1909 by Charles Brickdale, the chief registrar during that time, not to protect occupiers but to actually save the land registry's insurance fund from paying out compensations. Bevan argues that the justification for actual occupation has always been a bit shaky. He even makes the radical case of abolishing it altogether. But while it exists, Bevan admits that the courts have been very flexible, as in they have accepted occupation even when the person was absent for very long periods of time, but they do have an intention to return, in which that does relate to you. Additionally, another writer named Dixon, in which his article on Penistone strengthens that argument because it says that actual occupation is in fact fact sensitive and requires some physical presence with some degree of permanence and continuity. As said before, the 2 week hospital stay should not break actual occupation as your belongings were in your locked West Wing. So on actual occupation, you actually do have very strong support. The famous case of Williams and Clint's Bank and Boland said a wife living in a matrimonial home had an overriding interest. But, and this is the big but, Boland distinguishes from Flag precisely because Boland only had one trustee. You have two trustees in your case in which the problem does return. Now, let me get into my expertise, since I don't really have any info about whether Upton Abbey is registered or not. But I do want to get into the situation if it's still an unregistered land and whether that would change anything. So in unregistered land, the rules are a bit different, but the outcomes are surprisingly similar. Instead of Land Registration Act, we look at the doctrine of notice. An equitable interest binds the purchaser only if the purchaser had notice of it. On notice, you actually have good arguments. In the case of Hunt and Luck, it says occupation is notice to all the world. The developer inspections should have been put on inquiry whether they saw a locked West Wing with your belongings inside. Author Simon Cooper has written an article comparing Commonwealth registration systems. He explains that in unregistered land, purchasers are expected to investigate carefully and can be bound by interests where they ought to have discovered through reasonable inquiries. Your locked West Wing should have triggered that. However, there is a landmine though. If your interest is considered a registrable land charge under the Land Charges Act of 1972, like for example, let's say an estate that contract that wasn't registered, then it's void against a purchaser even if they knew about it. The harsh case of Millenbank and Green shows that a son had an option to buy a farm, but it wasn't registered. The father sold to the mother for a fraction of its value, and the court said the son's interest was actually void. Yeah. So your property estoppel claim doesn't really fit nearly into the land charges category, so it's probably a residual equitable interest subject to notice, and that's better for you. But even then, the same origin problem under the Land of Property Act of 1925 applies to the unregistered land as well. So you're still facing the same hurdle. So now let's move on to the violinists across the block. Miss Gray. You might find this a bit frustrating, but her legal position is actually better than yours. Why, you may ask? Because she actually doesn't have to rely on equitable claims like proprietary estoppel. She has a formal lease. Since 2020, she's been paying rent monthly, and she has exclusive possession of the East Wing. Now, under the case of Street and Mountford, the courts look at substance instead of labels. If someone pays rent and has exclusive possession, that's a lease and a proprietary interest, and a lease binds purchasers. Under Schedule 3 of Paragraph 1 of the Land Registration Act 2002, a lease for 7 years or less is an overriding interest. The fact is hers started in 2020, so it's well within that range. Also, overreaching doesn't really affect her. Overreaching applies to beneficial interests under trust like your equity. It doesn't apply to a leasehold estate. Now, a writer named Michael Hartwood wrote an article arguing that lease should be treated as real property and not personal property. He says that all classification of leases are as chattel reals is a historically accident, stemming from a time where only freeholders were seen as truly owning land. Hartwood argues that today, leases provide occupation, physical security, and a home in which they function just like any other freehold for most people. So Mrs. Gray lease is a real property and she gets full protection of the registration system, which means she can likely stay. The developer inspected the east wing and saw her there, and they just cannot claim ignorance. I know it's hard to hear, but for you, since she's only been there for since 2020, and you've been there since 1956. But that's the difference between equitable interest and a formal proprietary right. So now let me just summarize your position realistically. Well, your strengths are you have a clear assurance from your father in 1985, and you have decades of reliance as you never left, you spent £80,000, you built an extension, and you maintain the garden. You have strong case laws backing you up, like Turner and Gillett, and writers like Jean Mee stating that family insurance like this are taken very seriously. And you were in actual occupation, and your 2-week hospital stay doesn't defeat that. Chris Bevan confirms that actual occupation is facultative and even flexible. However, your weaknesses being mainly overreaching sadly still, because your sisters were two trustees and the purchase money was paid to them jointly. Your equitable interest has likely been detached from the land. Nicola Jackson also states that shows that the land on overreaching is a bit messy, but the bottom line is that 2 trustees are enough to overreach, even if you're in occupation. And Farros argues that the registration system prioritizes marketability over static security, and you're losing on that side of the trade-off. So you probably cannot force Regent Estates to let you stay. Instead, your claims would be against the sales proceed, and you might be entitled to have the share of the money. So I will now be honest with you, Mr. Hill. The overreaching hurdle is very high. The courts have consistently held that 2 trustees are enough, even if the beneficiary is in actual occupation and even if the purchaser knew about it, as flag is still the good law. So now what I recommend you for now is that firstly, do not move out voluntarily. Stay in the West Wing as your physical position gives you practical leverage and the developers would have to go to court to evict you. Second, register a notice of or a restriction against the title of Uptown Abbey immediately. Even if overreaching does apply, registering your interest protects your protection in negotiations. Third, consider making a claim against the sale proceeds. Sean and Caroline received the money from Regent Estates. That money should have been held on trust for you. To the extent of your equitable interest, you might be entitled to a significant share and potentially representing the value of the West Wing money, of the money that you spent on renovations and improvements of the property. Now, Otto Ferris does make a final good point in his article in which land registration system needs a principled narrative that protects good faith purchasers but also guards against fraud and short practice. While your situation is not fraud and is a family promise, but the system does treat you the same. That's why you still need to find a compensation and not just the house. Well, I feel like that should all be from me, Mr. Hale. I would just like to thank you for testing me on this. I'll send you a short written summary, but please call me if anything's unclear. Alright? Goodbye.